This case is horrible. I know that's a lot of time. And I realize how old you are, and I realize that prison time is hard time, right? So I consider 5 to 25. I don't automatically say, oh, I'm giving this person 25 or 24. The court will sentence you to 25 years in the prison.
From violent offenders to heartbreaking tragedies, justice hits hard. This is the top 5 highest sentences in Judge Boyd's court.
Mr. Rodriguez, I realize this is a lot of time. How old are you?
34, man.
All right, you're 34. All right, you entered a plea of no contest on February 21st to the offense of murder. You entered a plea of true to the enhancement. The court found the enhancement true based upon your plea of true to the enhancements in States Exhibits 1 and attachments. And the court found there was sufficient evidence to find you guilty, and the court found you guilty.
Your Honor, he would like to allocate.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record.
Fabian Vega.
All right, defense.
I believe he just wants to share with the court a few reports.
Yes, ma'am. I want to say that I know I took a lot that I can't get back, and I want to apologize to my victim's family for so much pain that I caused them and for their loss. And I regret everything I did. So emotional and stuff like that. I know I'm going to prison, and I would want to get myself right over there by getting my GED, because I never finished high school. Take drug classes. I had a problem with drugs in the past, and take parenting classes to better myself, to go home to be a good father to my son, and just go home clean and be positive out there, and don't find myself in no more of the situations like I'm in right now. And I ask that you show mercy on me on the sentence. A wife and a son that need me out there, and I like to go back to them as fast as I can.
Thank you. Mr. Vega, you stated when you were asked about this incident here, you said that in here it says, my neighbors told me them where I was, my name, and that I had tattoos. I tried to fight it with self-defense. So are you saying this is self-defense?
No, sir.
Okay, but so that's wrong in here, is that correct?
Yes, sir.
Okay, so did you lie in here?
No,
Excuse me?
no, sir.
But it says self-defense here.
I was in fear of my life at that moment. I've been shot at, but he seemed proud in the past, so it was out of fear, I guess.
So do you feel that you had a right to kill that day?
No, sir. I feel like I should have handled the situation a lot different. It was out of fear, I guess, like my reaction.
You know, you didn't just, you killed one individual, but then you shot 3 individuals that day. You do realize that, correct?
Yes, sir.
And that you were shooting into a park, Father Benavides Park. You're aware of that.
Yes, sir.
And there are people out there that you were randomly shooting at. You're aware of that.
Yes, sir.
And then you say a witness of yours backed out. Who was the witness?
My roommate, Caleb.
Caleb was willing to testify against you. You do realize that.
Yes, sir.
So how did he back out? Because he was going to tell the truth?
I don't know.
No further questions, Your Honor.
All right, Mr. Vega, why does it take you going to prison for you to wake up and realize that you what's right from wrong? I don't understand that. Like, why does it take going to prison for you to say, I'm going to get my GED, I'm going to be in my son's life, I'm going to be a good parent, I'm going to get off drugs? Because I'm looking at your history, and you've been in trouble with the law as a juvenile since 2013. And it started with graffiti at a church or a school, and you were on deferred for that for 6 months. And I know, because I've toured their facilities, I know they give you an opportunity for your GED and for you to do all of that and get your life on track. And then you pick up another case in 2014. Then you are in need of supervision in 2015. And then you have a possession in 2015 and evading in 2015. And this, what I'm talking about, is just your juvenile history. And it goes on and on and on. 2016, 2017, all juvenile. And then you have this incident out of Waco, where I'm assuming you went to TYC. I know they don't call it TYC anymore, but you went there. And it appears that you didn't learn anything. And then now we're here for this. And how old are you?
23.
All right, you're 23. And I know what young people think because I was in your position. When people get sentenced to go to prison and they're young, they think it's the end of the world for them. But time goes by so quickly. I can't believe how quickly this year is passing. And you still have a chance to improve your life. Like there's someone here who's dead. They're not, and I want you to think about this, they're not having graduations. If they were going to graduate, you can say, hey, that person was a horrible person too, or did horrible things. But guess what? They're not going to graduate. They're not going to see any grandchildren maybe they were going to have. They're not going to get a chance to improve themselves here on the planet because they're no longer with us. So there are many things that they won't be able to do. I don't understand why, if you have a child who's 6 years old, instead of doing this, why were you not spending as much time with them as you could? The witness tells me that you're very, very loving. Then a very loving person would be, I want to spend as much time with my son as I can because I've missed out so much on his life. I went through Child Protective Services, so I want to make sure my son doesn't go through that. I didn't have a good father, so I want to make sure my son has that. That's not so much about you knowing right from wrong. That's just like common. You understand?
Yes, ma'am.
All right. The court will hear argument. His cap is 25 years. State, I'm assuming you're asking for 25?
Yes, Your Honor.
All right. And defense?
Our defense is asking for mercy, and we're asking for that in a situation where there's been a death, a murder, and that life can't be brought back. So there's nothing we can say to change that fact. This young man, having growing up without a father and mother, there's nothing we can do to change that either. This young man making poor choices, not being around his son as his son was growing up, and being rather with people who are involved in drugs and guns. There's nothing we can say to change that either. But we have heard from him. He knows that this is pretty much his last chance to turn his life around. He doesn't want to spend the rest of his life in prison. So we are asking for mercy, Your Honor. He has explained what his plans and goals are to the court, being get his high school diploma so he can get a decent job out there, and take enough education and courses and therapy so that he's able to break his chains of addiction, Your Honor, and also learn to be a good parent to his son who's out there waiting for him, and his wife, Miss Brenda Torres, to be a good husband to his wife. We're asking for leniency from the court, full knowledge that we can't change the fact that we're dealing with a murder here, Your Honor.
All right. And Mr. Vega, I want you to know at some point in time, our actions are our own. We can no longer blame it on the rough childhood we had, because a lot of people had a rough childhood. A lot of people had parents that were not in their lives. Some people had parents who were in their lives and shouldn't have been in their lives. But I do take in consideration when I hear that, because as a defense attorney, I used to always get upset when the state would say, well, this person didn't commit a murder and they had a rough life. I want you to know I look at people as individuals. You understand? All right. So I'm going to sentence you to 25 years in the prison. There's an affirmative finding of deadly weapon. Take in consideration 2020 CR 6409, night mag number 68664 and 674688. That's the county court cause number 674688. I'll ask for you to have the therapeutic community. You'll have to request that. That's to help you with any drug addictions that you may have. But if you don't request it, they're definitely not going to give it to you, and I can't make them give it to you. You entered a plea of no contest on July 16th to the offense of murder. According to the plea bargain agreement, punishment is to be assessed at a cap of 25 years in the prison. There are no applications, and of course, for murder, you're not eligible for probation. Have both parties had a chance to review the PSI report?
Yes, Your Honor.
Yes, Judge.
Any objections to the PSI report?
Not from the state, Your Honor.
No objections, Judge.
All right. Any witnesses from the state or the defense?
Not from the state, Your Honor. We just have argument.
No witnesses, Judge.
All right. Then the court will hear argument. State, I'm
Yes.
assuming you're requesting that I hit the cap?
Yes, Your Honor. We feel that the 25 is already taking kind of evidence and other things into consideration. But especially after, if you read the PSI, and you've had a chance to review the report, to review the autopsy, there's just several things I want to highlight. Not only did Miss Diaz shoot Christopher Jones in the back, she left him to rot, Your Honor. She left him alone in that house for the better part of a month. And there's evidence that she returned at least once, but likely more. She took his phone, his wallet, his watch, his dog, and his car. She used his car, she drove it around, she spent his money, she racked up his calls, she tried to collect rent from one of his friends, she tried to sell his equipment, and in that event, she got the murder weapon stolen. She not only tried to convince his family and friends that he was still alive through her texting them on his cell phone, she also tried to convince the police he was still alive. She impacted his entire family, his mother, his sister, and his aunt, and the children that he had only recently connected with. And so 25 to us is the only thing that even came close to getting any sort of justice, Your Honor.
All right. Defense.
Hi, Judge. Excuse me, on behalf of Ms. Diaz, we believe the PSI does discuss quite a few things that I would ask the court to consider. First, regarding the PSI, it talks about her children, and it says she has 4. She actually has 6, just so the court knows. Factually, there are some inaccuracies in the PSI. She has 6 children rather than 4. It does discuss also some things that happened to Ms. Diaz as she grew up, and some of the difficult things she faced as a young person. Now, addressing what happened on this day, and the state talks about the fact that the 25 takes into account all the factors that led up to what happened on this day, and perhaps it takes into account some of it, but Ms. Diaz, in her description of what happened that day, you know, she comes clean and she tells the court exactly what happens that day, and she's correct and she's truthful with the court in the PSI. And one of the things I think the court, you know, the state wants you to believe that she just left in there and did nothing regarding the police, but in fact, she tells the court through the PSI that she thought the police had been notified through these people, because she goes immediately and tells somebody what happened. And she tells through the PSI, she says, I thought the police had been notified. And if you read the stipulations, you'll see that in fact, the police were notified. The police were called and told, and they did nothing about it. So while Mary did not call the police, she told people what happened, and those people called the police and told the police. And then for whatever reason, the police didn't believe anything about it. And so when I think it was Vanessa and her roommate or her wife, whoever it was, when they called the police, for whatever reason, nothing happened. Now, the problem that Mary then ran into is as time passed, you know, it just kind of, you know, it became more and more difficult, and it's kind of snowballed on Mary. And certainly she should have come forward, and she didn't. And she realizes, as she stands here today before the court, she realizes she certainly should have come clean. But as time passed, it became more and more difficult, and she made bad decision after bad decision after bad decision, which led her to make the one decision that, you know, that perhaps was her one good decision, that was to accept responsibility and come before this honorable court today and say, Judge, I'm here, I accept responsibility. You can see I don't think you've seen a PSI that is as accepting of responsibility as this one is. She tells you exactly what happened. She tells you why it happened. She tells you what was going on between the two of them and everything. And the good thing, if there is any good thing from Mary's version, is it's completely supported by the stipulated evidence. All the trouble that she says they were going through together is supported by the stipulated evidence. The fact that she tried to do something right after it happened and the first aid she tried to administer is supported by the stipulated evidence. So as she stands before you, she is accepting responsibility. She understands the court has to make this decision. She wants the court to know that she understands she's hurt many people. She's made a community feel unsafe. She's caused so much emotional stress to all the people that know about the case. She's done things. She's hurt his family. She's hurt her family. She's hurt everyone touched by this. But she can't change that. She's by accepting responsibility, she's hoping people will see that she's doing everything she can to make it right, even though it's years too late. And then when we talk about years, in this case, we're talking about a cap of 25 years. And the court, has the ability to consider, obviously a cap of 25 means 5 to 25. And we're certainly not thinking by any stretch the court should consider anything between 5 and 25. The court shouldn't. This is a murder case. This is the taking of someone's life. But we're asking the court to perhaps consider something between 20 and 25 years. And I would ask that the court read the stipulated evidence, how it compares to her statement of the facts. I would also ask the court to consider the fact that she spent 1 year in jail and then 3 years on full house arrest. She didn't ask to go work. She
And
didn't ask.
counsel, what does she mean if you turn to page 11? of the
Yes, I was
PSI
going to
report?
get to that part.
All right, if you can
You're
tell
talking
me
about
what
the
she
fair
means.
part?
Yes.
Yeah. So when she was asked about that, I asked her about that. I said, Mary, this sounds terrible. And she says, Charles, what I was trying to say was, when this happened, he had been, our situation, his and hers, was a volatile, abusive situation, and I had to make a decision on what to do, how to react. And I reacted in a way that turns out I had to make a decision that at the end wasn't fair to me. And in other words, she doesn't mean that this isn't fair. She means the result, she made a decision that in the end, the result wasn't fair to her, and that she was placed in a situation where she had to make a decision that it wasn't fair to make her make that decision. In other words, he placed her in the untenable situation where you've got to decide to make this decision. And it's not fair to put a person in a situation where you've got to choose either I'm going to do something terrible to you, or you have to do something terrible to me to keep that from happening to you. And that's not a fair decision to put another person in. And that's what she meant. She certainly does not mean that it's not fair that she's before this honorable court. So, so I asked her about that. I've cringed just like I'm sure you did when you read that. But that she's not inferring or not telling this honorable court that it's not fair that she's here. It's certainly fair. She's here. And if it wasn't fair, we wouldn't be here. We'd be in trouble. Certainly, Mr. Tochi and myself, if we didn't think it was fair, we wouldn't have pled. We wouldn't be here. She understands, she accepts. What she meant was it's not fair to put in a person in a position to have to make that choice. Hey, am I going to have to hurt you? Are you going to hurt me? And that's not fair to make a human make that decision. That's what she was trying to say on that day, not to you, but to Chris. And so that it was just an unfair position to put another person in. Thank you. So anyway, back to what I was saying is just when you make the decision, we're asking you to consider perhaps, even if it's 22 or 23 years, considering how she came clean in the PSI, and it's shown that in the stipulated evidence. She spent 1 year in the county jail. She spent 3 years on full house arrest. We believe that those factors all combined would justify a sentence of 22 to 23 years, and we ask the court to do that. Thank you.
All right, state.
Just briefly, Your Honor, as you always say, I feel the truth is always somewhere in between. We obviously don't have Mr. Jones' side of the story, and we now have Ms. Diaz's 4 years later. I believe it would probably be somewhere in between, Your Honor. And at the end of the day, it doesn't take away all that she tried to do to hide the truth. She had multiple occasions to tell the detectives the truth. She spent hours being interviewed and she still denied the truth. She also had contact with the police at least once, I think maybe twice, between when he was killed and when the body was discovered. And at no time did she say anything. She knew he hadn't been discovered and the police hadn't gone because she went to that house, which she talks about, the fact that she went back to the house and his body was still there and she took the dog. So, Your Honor, 25 is the only real option here.
Okay, and I remember, the steps, and I always reread steps. And part of the stipulations, it says that there were text messages sent that appear to be text messages to make it seem as though the complainant was still alive.
Yes, Your Honor.
Did I read that correctly?
Yes, Your Honor. To multiple friends and family.
All right. Does anybody want to address that part of the stipulations?
No,
Okay.
like I said, at some point it snowballed and she got caught up in that.
All right. Anything else from either side?
No, Your Honor, just a reminder that we do have the family for victim impact on it.
Hope God has.
Ms. Diaz, I want you to know when the state makes an offer a cap of 25, always consider the full range, because when people offer a cap of something, so I consider 5 to 25. I don't automatically say, oh, I'm giving this person 25 or 24. I consider the entire range of punishment, okay? And I understand what the defense is asking for. I understand what the state is asking for, and I appreciate both people being reasonable in what they are asking for. All right, as previously stated, the court is finding you guilty. The court will give you credit for any time served. The court will sentence you to 25 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal.
During the first 10 years of Michelle's life, did you think there was anything unusual about her not being able to eat solid foods? Well, other than that, she probably should have.
Given her state with cerebral palsy, I didn't know.
And the primary caretaker, Michelle, was Norma, is that correct?
Yes, sir.
And you live with Norma, you're not married to her.
Yes, sir.
Did Norma ever have any complaints to you about something she wasn't allowed to do for Michelle?
No, sir.
And you've read the report and you're happy with Miss, I can't do her name, Sitsu, the foster mother?
Yes, sir.
Okay, and I read you the expert. Do you agree with what she wrote?
Yes, sir, I do.
Okay. And do you want the best for your daughter?
I do, yes, sir.
And you've had a hearing in CPS court on Valentine's Day where you gave an affidavit of relinquishment of your parental rights?
Yes, sir, I did.
Okay. So do you feel sorry for what you either did or failed to do for your daughter?
At the time, I wasn't aware, but yes, I do.
Okay. So you realize the judge is probably going to send you to prison.
Yes, I do.
Are you asking for something maybe in the 20-year range as opposed to 35?
I am asking for leniency.
Okay. No further questions. That's a prosecutor. You may want to ask you something.
Mr. Kennedy, my name is Zach Dunn. I'm one of the prosecutors in the Family Violence Division. I should have a few questions for you, and some of it goes to your statements in the PSI, which is the report that the judge is looking at right now. You basically mentioned on kind of the last page of it that you really kind of didn't know or were unsure of the fact. You said you had ignorance of your daughter's condition. She was diagnosed with cerebral palsy at birth, though, correct?
I do not know.
With respect to her abilities, things she was able to do, did you notice any kind of comparison between her and other 10-year-olds?
Actually, comparison between her and when I was going through high school, I noticed that there was children that were similar.
And are you aware of how much she weighed as a 10-year-old when the police came to the residence for the first time?
I believe she was at 27 pounds, but I can't remember.
27 pounds as a 10-year-old. Does that seem normal to you or abnormal to you?
I do not know. I mean, when I look at, when I remember how there were others that were her age, more or less, even, and when I was going through high school, I saw that they were about her size.
You're saying when you went through high school personally,
When I went through high school,
you knew of 10-year-olds that were around 20 pounds in weight, or
we went to the kitchen cafeteria, and I saw others that were rolled around in wheelchairs that were about the same size.
and what did you make of the fact that Michelle, again, a 10-year-old, was unable to speak and barely even move when the police first interacted with her coming on scene? Is that normal behavior, you think, for a 10-year-old?
I think given that she had cerebral palsy, that it was normal.
And with respect to her diet, do you think it's appropriate to feed someone Oreos, milk, and Kool-Aid to sustain their life as a 10-year-old with cerebral palsy?
Michelle could not eat solid, so she couldn't even eat Oreos.
Okay, but at the time, does it surprise you, or is it surprising to hear now that y'all's statements at the time on scene was that, again, you fed her Kool-Aid, milk, and Oreos?
At that time, given that Numa was taken to her to the doctors, and that the doctors were aware of what was going on, I thought everything was okay. Given that now I know that it's not okay, because that could have all been avoided with the surgery of a G tube, gastrostomy tube.
You said you know about that now.
I do.
So if police had never come and CPS was never involved, what do you think the future of Michelle's life would look like? Again, at the time, she weighed 27 pounds as a 10-year-old. That was a few years ago.
Well, she did lose a lot of weight due to her being sick. It wasn't due to lack of us providing nutrition. It was due to her being sick that she lost weight.
No further questions, Ron.
All right,
That's
any
it, John.
follow-up?
A follow-up,
All right, may I
Right.
ask a question?
please.
All right, why was she never placed back in school?
When she was originally taken out of school due to the coronavirus.
All right, and then after
when
that?
we attempted to take her back to school, she could never keep the mask on. She would keep constantly pulling it off. And then they told her to no longer go back to school.
I'm sorry, what?
They told her not to go back to school until she could take care of that.
Okay. And I'm sorry, I'm trying to find the trial court certification form. Just 1 second. I'll have it. All right, so you're saying that they didn't allow her to come back to school because she continued to pull off her mask.
Yes, ma'am.
And the offense date on this is 2023. So help me, in 2023, were students still required to wear a mask?
I do not know. Your Honor.
All right, so you didn't take her back to school in the year of 2023.
No, Your Honor.
And I read the PSI report, and it said that you had personal insurance.
I do. Oh, I did.
All right, so at that time you had personal insurance, correct?
Yes, Your Honor.
How often had she seen a doctor?
I believe the last time she saw the doctor was in 2020. And I believe it was on a either annual or duannual checkup. I left that all to Norma to take care of.
All right, so the last time she saw a doctor was in 2020.
Yes, I believe so.
So did your wife, Norma, have the insurance card to take her to a doctor?
No, Your Honor.
All right, so
No,
you
that's
had
not
the,
his wife, they just live together.
all right, so the person you lived with, were you in a romantic relationship with them?
Yes, Your Honor.
All right. And were you all living together as boyfriend and girlfriend or husband and wife?
Yes, Your Honor.
All right, and so you left her in charge of taking care of your child?
Yes, Your Honor.
And is she the biological mother of that child?
Yes, Your Honor.
All right, so you didn't give her your insurance card to take her to the doctor for emergencies?
I never was issued one. Everything was done electronic.
All right, so since 2020, you never took your child to the hospital, emergency rooms, or to see a pediatrician?
Personally, I haven't. I do not know what Norma has done.
All right, did you ever ask her, hey, she's not eating right, something's going wrong? Have you taken her to the doctor?
This will actually all happen recent, like because she got sick because of everything that happened. We took her to the hospital to Christus Santa Rosa at first. And
When was that? Was that in 2023?
yes, Your Honor.
All right, I'm talking about before 2023. Unless, and if I'm wrong, correct me. And I won't take offense to you correcting me. It appears that this is something that was happening over time. Am I right? The fact that she's not gaining weight, she's not eating?
No, Your Honor. The way we were giving her nutrition over the time period from her birth until the time that she got sick was the same constant method.
Okay.
And then all of a sudden she gets sick and she lost the weight.
So what was her highest weight? Because this is saying that she was 27 pounds at 10. So before she started dropping all of the weight, what was her weight as a 10-year-old?
I believe it was either at 40 or 45 pounds.
So 45 pounds, and then all of a sudden she's at 27 pounds.
Yes, Your Honor.
So you didn't think to take her to the doctor when she dropped down to 30 pounds?
I would be at work, so when I would come home, I'd always want to try to sleep or relax just before sleeping.
All right, and how far did you go in school?
For school, I graduated from St. Philip's College.
Okay,
I got my certificates for aircraft and power plant.
all right, thank you. Any other questions, defense?
No, Your Honor.
State, any other questions?
No, Your Honor.
All right, the court will hear argument. The state is opposed to the application. State?
Your Honor, this is an individual that essentially the state doesn't believe has taken responsibility. The litany of I don't knows and I'm not sure. This doesn't replace the fact that you're talking about a 10-year-old who had, as the medical facility diagnosed her with, quote, extreme prolonged malnourishment. 10-year-olds are somewhere in the range of above 70 pounds. This is a 27-pound individual who, through the defendant's own words, was fed Oreos, Kool-Aid, and milk. As if being a child wasn't a vulnerable enough position to be in the world, to be diagnosed with cerebral palsy at birth and have parents that don't take you because their insurance quote has expired and knew about first they knew about the diagnosis, but then they didn't know about the diagnosis, as they later said. The state would, of course, respectfully request that, the court take all these factors into consideration, given how this person completely disregarded the health of a young girl for many years on end, Your Honor.
All right, defense?
This case has a certain horribleness factor, especially to me as a parent. I can't imagine not feeding your child, and this is my second sentencing on this crime in a week.
Yes.
So I didn't know that many people weren't feeding their child. In representing my client, he's basically been clueless. I've had a very difficult time getting to him to understand what he did or did not do and what he should have done or should not have done. That doesn't condone what happened to his daughter. One thing I don't understand is how she went to healthcare providers and no one noticed anything, especially on the day in which she was taken to a healthcare provider a second time, and that's when she was taken into police custody, CPS custody.
Okay.
Okay, and you have terminated your parental rights, is that correct, sir?
Yes,
That's it, John.
All right, one final question. So what were you eating?
I would eat out a lot.
Okay. And did your weight ever drop at normally low?
No, Your Honor.
And how much did you weigh?
Before I was at 277.
All right, so if your weight went from 277 down to 100 pounds or 90 pounds, would you go to the doctor?
I would find out what's going on, yes.
Okay. All right, the court is going to deny your application. The court will find you guilty. I understand that there may have been other issues at play here as far as maybe the mother was in charge of taking care of your daughter and during the day-to-day. So I am taking that into consideration. I'm going to sentence you to 34 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with the complainant. There's to be no unsupervised contact with minors. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Which one? Yes, Judge.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Mr. Kennedy, I understand that you're probably hurt by what happened to your daughter. I do understand that. But children are 100% dependent upon adults. They're dependent on them to feed them. They're dependent on them to clothe them and for them to be educated. And you can't say your responsibility, I'm just outside working, somebody else is taking care of my daughter and I'm not noticing anything. You understand?
I understand, Your Honor, and I wish I did really know what was going on, like when CPS came by, my caseworker, she gave me all this paperwork
Mhm.
and I was reviewing it. It was at that moment that I understood
Okay.
the level of care that she demanded, that she needed.
All right. Well, good luck to you. Okay.
Yes, Your Honor.
All right. Thank you so much.
Thank you.
Thank you. Yes. All right. You entered a plea in each of these cause numbers on September 10th. You entered a plea and the cause number ending in 5-9 to count 1 and count 2. You entered a plea of guilty and you pled true to the repeater allegation. And the cause number ending in 6-1, you pled guilty to counts 2 and counts 3 and true to the repeater enhancement allegation. In each of the cause numbers, the court found there was sufficient evidence to find you guilty of each counts and found the enhancement true. According to your plea bargain agreement, punishment is to be assessed at a cap of 40 years in the prison. There's an affirmative finding of a deadly weapon. There are no applications. The cases will run concurrently. The state is taking in consideration 2024 CR 5164 and 2024 CR 007370.
In fact, is a serious case, but Johnny has serious problems. And I'm asking that the court give him mercy today, and I am asking for the minimum 15 years. I'd ask the court to take judicial notice of the court's file. In it, there's a competency report that was completed, and in that competency report, the doctor notes a few things about Mr. Munoz, which I think frankly should be taken into account and decided in his sentence. Mr. Munoz appears to have a mental illness of some kind. It's never been diagnosed, but the doctor did review records, medical records, did talk to his family. His father did have a mental illness, and it's been suspected that Johnny has one. Johnny got locked up at 12 years old for the first time. He has had trouble with drugs and alcohol. He is an alcoholic, and on this particular occasion, he states that he was on a bender. And it certainly doesn't excuse what he did. He knows he's responsible for what he did. But he did what he did because he was on drugs, and he was on drugs because he has an addiction. So we have a cycle that Mr. Munoz has been having to deal with his entire life. And yes, this could have gotten very, very bad. But thankfully, it didn't get as bad as it could have. I think that Johnny needs to hopefully be put in a therapeutic community at prison. I think that he needs a whole bunch of counseling, a whole bunch of classes that, and I hope that TDCJ is going to offer that and that he takes full advantage of that. But I don't think that he's a monster that needs to forfeit the balance of his adult life. I think that an appropriate sentence would be somewhere in the 15 to 20-year range, and that's what I'm asking that you do. Thank you.
All right, so I have several questions. My first question is, what is his mental illness?
I don't think it's ever been diagnosed, Judge, and I don't want to tell you that for sure he has one. Frankly, given the facts of this case, I thought from the get-go that I should file a competency exam, also based off of the defendant's initial behavior. That very well might have been just because he was on drugs, but there, as far as I know, there's not been an official mental diagnosis.
So he is competent,
Yeah, oh, yes, yes,
and he was sane at the time of the offense.
yes.
All right, so then here's my next question. Previously, he went to prison for aggravated assault with a deadly weapon, is that correct?
Yes.
So why did he have a gun? Because he's not allowed to have a weapon.
I don't have a good answer for that, Judge. He shouldn't have had a gun. And I know that I'm asking a lot, but that's my job to ask for a lot.
No, I understand.
And I know very well, Judge, he might not be he might not be deserving of mercy, but that's kind of the point of mercy, is to be merciful to the people that don't deserve it. I'm just asking that you show him a little bit of grace today, Judge.
All right, I don't think 15 years is appropriate for this offense. For the aggravated assault with a deadly weapon, how long was he in prison?
15 years.
So he was in prison for an aggravated assault with a deadly weapon for 15 years. And previously in his criminal history, he was placed on deferred adjudication. What was that offense? Was that the deadly conduct?
I believe so, Judge.
All right, this is where I'm at. And I will tell you, whenever you go to judges school, they always tell you, say as little as possible on the record, right? But I'm a firm believer that when you explain to people a little bit why you're doing the things that you're doing, so people won't think it's arbitrary. When I was a defense attorney, I would always feel that people were just randomly maybe throwing out numbers. And I'm not saying that the state is doing it in this case. I think the offer that they tendered is an appropriate offer in this case. A lot of times when people have cases that are aggravated assault with a deadly weapon, if somebody's pointing a weapon at somebody, if somebody's showing a weapon at somebody and threatening them, people focus a little bit of what might have happened. Well, this could have been a murder. So you should sentence him to 40 years. I do know that he has maybe some mental health issues. Maybe that's brought upon the fact that he has been in and out of custody since he's been 12 years old. And if you have somebody who's in and out of custody since they've been 12 years old, I know that there is an issue, perhaps parenting, because I don't take the idea that there are bad seeds. I don't think a child is born and everybody says, I knew since the time that child was born, time when they threw their bottle out of the crib or threw up on somebody, I knew that child was going to be a problem. So I think a lot of it has to do with environment. I think a lot of it has to do with parenting. Of course, there are issues with drugs, alcoholism that really is not an excuse for behavior. So I want you to know that I reviewed everything, and the reason why I remember your case and I remember you, and the reason why I asked them to give me the stipulations again is because I want to be sure of everything that I read and make sure that my memory is correct on things. Of course, you know, this one is not an appropriate situation for probation because that's been tried with you before. All right. Is there anything you wish to say before I pass ruling? All right. I want to let you know that I wish you the best in your life, but you're going to be going to prison today. The cases will run concurrent with each other. I want you to know, even though we're dealing a little bit in what ifs, you should really consider what ifs, because you could have killed officers that day. You could have killed people who were just at that hotel trying to get a good night's sleep. You understand? And each cause number, the court will take into consideration 2024 CR 5164, 2024 CR 007370. I'm going to recommend for you the therapeutic community mental health unit. I don't know if they'll accept you into that unit based upon your criminal history, but I do know that if you don't request it, you definitely will not be placed in that. I have no jurisdiction to order them to place you in that community, but continue to ask for it.
Yes, ma'am.
All right. And how old are you?
43.
All right. The court is going to sentence you to 35 years in the prison and give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Off the record, here's the thing. I know that's a lot of time. And I realize how old you are. And I realize that prison time is hard time, right? But this is what I want you to understand. One, this is a part of punishment. But two, nobody ever knows how long they're going to live. Nobody ever knows what's going to be happening with parole. But what you need to do is make sure that you get your life in order, right? And be the best that you can be. And at prison, do not become institutionalized, because it's easy to become institutionalized. It's easy to go to prison and become a part of this thing where you're just committing crimes in prison and other people are committing crimes around you or towards you at the prison. Don't become institutionalized. Just try to be the best that you can be each day. And, you know, look forward to go in there with the understanding that, hey, there's a great chance that I'm going to end up getting parole, and just try to better yourself. So when you do get paroled, that you're ready to be in society, do the right things. And if you need to be on medications, to be on medications. And if I'm still here, who knows what will happen, right? But if I'm still here on the bench and you are lost, don't know where to go to get help, you can always come back and see me, okay?
Yes, ma'am.
And I say, if I'm still on the bench, who knows? Maybe I win the lottery or something. I don't know. All right.
All
So
right.
good luck to you, okay?
Thank
You're welcome. Thank you, counsel. In each cause number, you're charged with unlawfully carrying a weapon with a felony conviction. Normally, the range of punishment for that offense is anywhere from 2 to 20 years in prison and up to $10,000 fine. If the state is able to prove up the habitual allegation, then the range of punishment will be 25 years to 99 years or life, with a possible fine up to $10,000. Did you understand?
Yes.
All right. If you have, according to the plea bargain agreement, state is proceeding on count 1 in each cause number. Punishment is to be assessed at 50 years in the prison. There are no applications. The cases will run concurrently. State will take in consideration 2023 CR 10985 and 2023 CR 10984. Did you understand that to be the plea?
There's actually one additional one, Your Honor.
Yes.
Left off 2023 CR 11151.
11151.
Yes, Judge.
Any objection to the court writing that in as a part of the plea bargain agreement, counsel?
No objection, Your Honor.
All right, and then the court will take then the agreement is also to take in consideration 2023 CR 111. And states exhibits 1 and attachments in your plea are true, the court will find the enhancement true, and the court will find you guilty of count 1 and each cause number. Are you proceeding with sentencing?
We could, Your Honor.
Anything you wish to say on behalf of your client?
Only this, Your Honor, there's outside of the agreement, the no contact, there's a young lady by the name of Cassandra in the no contact that is Mr. Rodriguez's daughter. Chris loves his daughter very much and he would like to have contact with her. He understands he will no longer have contact with her mom, but his parents who are here sometimes act as a conduit between the two of them, Chris and his daughter. And certainly Chris does not want his daughter to ever think that he doesn't want to have contact with her or that he would agree to such a thing. So he does love her very much. He wants to be able to do things like send birthday cards to her, maybe through his mom, and keep in touch as best he can under the circumstances that he's going to be under, which are him being in TDC and his daughter being in a different state under the custody of her mom, who will not have contact with Mr. Rodriguez. So what we're asking for, Judge, is the very limited contact that might occur where Chris would send a birthday card to his mom would relay that to his daughter, that sort of thing, just so that Chris can have make sure that she knows that he certainly loves her very much and wants to be there for her, but obviously can't because of the circumstances of the sentence.
State.
Yes, Your Honor. In the case that was, one of the cases that was taken into consideration, the sexual assault, one of the counts in there was endangering the child was present during the alleged assault. It actually happened with her on the bed. She is under the age of 4, and so at this time, we do not feel contact is appropriate, Your Honor.
All right, and that was
Cassandra, and then
an alleged sexual assault
it was
against.
sexual assault against her mother, and then one of the other counts in the indictment was for endangering a child.
And just for the court's edification, Your Honor, there's a lifetime protective order against for Mr. Rodriguez, not for Mr. Rodriguez, but where he is. I think the court understands she is the protected person. He is the excluded person. That's a lifetime protective order with the mom, but he did ask, and the state agreed under those civil circumstances that he could have contact with his daughter.
All right, is there anything you wish to say?
It's just that I have a protective order in place with the mother of my children, Allison Harris. That's for life. I understand that and completely fine with abiding by that. I just don't see why I need to not be able to have contact with my daughter at all for the rest of my life.
All right, so I've read the police reports, right? So I'm assuming that you love your daughter. Am I right in assuming that? And you would never want to do anything to hurt her. Hurting her mom is causing her emotional damage. Do you understand that?
Yes, ma'am.
And I don't know why when people go to prison, they expect for people to wait for them. Like nobody's obligated to wait for people when they go to prison. I mean, it's not like the movies where somebody's coming to see you every day at the prison and just waiting at the prison to pick you up and I'm going to be faithful to you. That rarely happens. There are consequences when people make choices. Sometimes the consequence is you go to prison and nobody's waiting for you. It's like, yeah, I'm done. Maybe if you get out and you start acting like an upstanding citizen, we can get back together. But guess what? I don't owe you any fidelity while you're in prison. So all of this started over the fact that you thought that she wasn't being faithful to you while you were in prison. And how long were you gone in prison?
This last time, ma'am?
Mhm.
2 years and 9 to 10 months.
All right, so why do people think that somebody should wait for them for 2 years? That's 2 years. And then when people are out of prison, usually they're not faithful, but they want somebody to be faithful for them in prison because technically they have to be faithful because there are no girls in here at the male prison unless they're guards, right? And then we want people to be faithful because we got to be faithful. So here's the thing. She can contact you if she chooses to contact you. when she's of age. Right now, I'm not going to order contact. So as previously stated, in each case, I'm finding you guilty. I'm finding the enhancement true. Court is going to sentence you to 50 years in the prison, give you credit for any time served. Cases will run concurrently, taking consideration 2023 CR 10985, 2023 CR, this one, 2023 CR 10984, and 2023 CR 1151. There should be no contact with Allison Harris and no contact with Cassandra Rodriguez. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Did you sign it in both places?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Rodriguez, I realize this is a lot of time. How old are you?
34, ma'am.
All right, you're 34. Here's the thing about having contact with children. At some point, she's going to grow up. Maybe you will get out of prison. You've learned something. You've gotten your life in order. And there's always room that people may have for forgiveness, right? But if you are not doing the right things, then people may not have forgiveness for you. So whether or not she forgives you and ultimately wants to have contact with her father, that'll be completely up to her. But you have to make the first step by doing what's right. You understand? All right, good luck to you, okay?